So good day, ma'am. Good day, classmates. So we are the group 5. Our topic is all about the separation of properties. Under the separation of properties, we have 8 subtopics. We have the grounds for separation of properties, grounds for the survival of the property regime, transfer of the administration of all exclusive properties to another spouse, regime of separation of property, family expenses, property regime of unions without marriage, rights of legitimate children, equal rights between men and women. So our first is all about grounds of separation of properties. So the grounds of judicial separation of properties are: first, we have the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. When we say civil interdiction, this is the legal restraint that is placed upon a person who is deemed incapable of managing his or her own property. Second, we have the spouse of the petitioner has been judicially declared an absentee. So when the spouse is absentee, this means that the spouse is not in his residence, his whereabouts being unknown, and it being uncertain whether he is dead or alive. Third, we have the loss of parental authority of the spouse of petitioner has been decreed by the court. So when the loss of parental authority has been decided and ordered with the court, so this is part of the grounds of separation of properties. Next, we have the fourth one: the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family. So factors that includes with this or having an affair are the negligence of the duty of the parent to provide the needs of his family. Fifth, we have the spouse granted the power of administration in the marriage settlements have abused that power. So when the abuse of authority as being the authorized personnel of the family has been abused, then it calls for the grounds for the separation of properties. Then the sixth is the time of the petition. Disposals have been separated, in fact, for at least a year, and reconciliation is highly improbable. So the disposals have been separated for a year, and getting back together is impossible. Next, we have the grounds for the revival of the property regime. So, in case of reconciliation, the property shall file a verified motion for revival of regime of property relations for the adoption of another regime of property relations in the same proceeding for legal separation, attaching the said motion their agreement for the approval of the court. So since the separation of properties and the separation of properties, the couple um are not allowed to remarry since their marriage is still valid. Although they are separated or the properties are separated, they are still married, legally married. So the agreement shall specify the following. First, the properties to be contributed to the restored or new regime. So since the properties are separated, the properties that will be contributed to the revival of the regime will be specified. Second, those to be retained as separate properties of each spouse. So those properties that will remain as their exclusive properties. Third, the names of their known creditors, their addresses and amounts owing to each. So in terms of debts, so the creditors are part of that. So the name of the creditors, the address, and the amount owned by the spouse. So the agreement of revival of the motion for its approval shall filed with the court in the same proceeding for legal separation, with copies of both furnished to the creditors named therein. After due hearing, the court shall, in its order, take measure to protect the interest of creditors, and such order shall be recorded in the proper registries of properties. So um, the ways the legal basis for the separation of properties will still be part of the property of regime that the couple will undergo. Next, we have the transfer of the administration of all exclusive properties to another spouse. So in the Article 109, the following shall be exclusive property of each spouse. When we say exclusive properties, these are the properties that is personally owned by the spouse. First, that which is brought to the marriage as his or her own. Second, that which each acquires during the marriage by gratuitous title. When we say gratuitous title, these are the properties that is um, given to the spouse or donated to the spouse. So third, that which is acquired during the marriage, that which is acquired by right of redemption, by barter or by exchange with property belonging to only one of the spouses. Fourth, that which is purchased with exclusive money for the wife or of the husband. The spouses retain the ownership, possession, administration, and enjoyment of their exclusive properties. Either spouse may, during the marriage, transfer the administration of his or her exclusive property to the other by means of a public instrument which shall be recorded in the registry of property of the place the property is located. So the spouse has his own right to honor the ownership of his or her property. The spouse of age may mortgage, encumber, alienate, or otherwise dispose of his or her exclusive property without the consent of the other spouse and appear alone in court to litigate with regard to the same. When we say to with the legal basis of mortgage, encumber, alienation, or disposing of property, the spouse has his own right to do that without the consent of the other spouse, since the properties is his exclusive properties. Next, the alienation of many exclusive property of the spouse administered by other automatically terminates the administration over such property, and the proceeds of the alienation shall be turned over to the owner of the spouse. Kapag sinabi nating alienation of properties, this is the transferring of alienation of property. This is the process of property owner voluntarily giving or selling the title of the property to another party. If it is administered by the another spouse, which is not the owner of the property, then it shall be transferred to the owner of the property. Property donated or left by will to the spouses jointly and with designation of the terminate shares shall pertain to the donee spouses as his or her own exclusive property, and in the absence of designation, share and share alike without prejudice to the right of accretion when proper. So kapag sinabi naman nating donated or left by a will, kapag andun yung designation or it is determined kung sino yung bibigyan, then it will become that spouse own exclusive property. Pero kapag hindi naka-specify kung kanino ibibigay or ibibigay sa kanila both, then it will be share and share alike, means it will be equally divided by both the spouse. Next, if the donations are onerous, the amount of the charges shall be borne by the exclusive property of the donee spouse whenever they have been advanced by the conjugal partnership of gains. When we say onerous properties or onerous transfers, ito yung tawag natin na with obligations or burdensome siya. With obligation or charges of future services. Like for example, when you say for example, si Mr. A, nag-donate siya ng lupa kay Mr. B para pagtayuan ng building. So, kapag dumating na yung time na kumikita na ng malaki yung building, itong si Mr. B, binigyan niya ng luxurious car si Mr. A which is mas mahal pa doon sa dinonate na lupa ni Mr. A. So, ganun yung onerous transfer, onerous donations. Yung mas malaki pa yung binigay mo doon mas malaki pa yung binigay mo sa nag-donate kesa doon sa dinonate niya sa iyo. Exchange kumbaga, but with obligation siya. Ano yung onerous transfer? Next, the retirement benefits, pensions, annuities, gratuities, usufructs, and similar benefits shall be governed by the rules and gratuitions or onerous acquisitions as may be proper in each case. So each spouse, they have the right to enjoy the benefits na nakukuha nila doon sa properties na owned nila since it is exclusive properties. They have every right to transfer it to anyone or to give it or to donate it to anyone without the consent of the other since it is exclusively owned personally by that spouse. Next, we have the regime of separation of property. Should the future spouses agree in the marriage settlement that their property relations during marriage shall be governed by the regime of separation of property, the provisions of this chapter shall be suppletory. So, before marriage, the spouse or the couple are informed that the properties will be governed by the regime of separation of property. Separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the absolute community. So, yung mga properties na hindi pa not agreed upon kung saan ba siya ibibigay, kung sa other ba or sa kabila ba. Basta yung mga properties na hindi pa known yung mga properties na hindi pa nilagay sa separated or exclusive properties will automatically belong to the absolute community. When we say absolute community, these are the properties that each spouse owned before the marriage becomes conjugal property. It will automatically be part of the conjugal property. Each spouse shall own, dispose of, possess, administer, and enjoy his or own separate estate, without need of the consent of the other. To each spouse shall belong all earnings from his or her professions, business, or industry, and all fruits, natural, industrial, or civil, due or received during the marriage from his or her separate property. So, like I have said earlier, each one of the spouse has the right to enjoy the benefits or do anything what he or she wants to his or her own property na hindi kasama doon sa conjugal property nila since it is that person's exclusive property. Kanya yon, owned niya yon personally, hindi belong doon sa conjugal property nila. Both spouses shall bear the family expenses in proportion to their income or in case of insufficiency or thereof to the current market value of their separate properties. So, the spouse has, both of the spouse has the obligation to bear the family expenses aligned to their income. So, next we have the family expenses. If you're in the process of filing for divorce, you may be entitled to or obligated to pay temporary alimony while legally separated. So when we say temporary alimony, this is the financial support that a person is ordered by a court to give to their spouse during separation or following divorce. In many instances, one spouse may be entitled to temporary support during the legal separation to pay for essential monthly expenses such as housing, food, and other necessities. When deciding whether to grant a request for temporary alimony, the family law judge will look at several factors based on divorce laws in your state. So, the court will decide kung sino ba yung magbibigay ng alimony depende doon sa financial capacity ng spouse. Particularly, kadalasan yung lalaki talaga yung nagbibigay since yung lalaki yung may. During the pendency of the action, child and spousal support will be governed by either written agreement or in the absence thereof from the ACP or CPG. After decree, either parent or both may be ordered by the court or given an amount necessary for support in proportion to resources, means of giver, and necessities of the recipient. Spousal support is considered as an advance to be deducted from the share of the spouse supported during liquidation. There may be restitution of spousal support if, after decree, the court finds that the person providing support pendente lite is not liable thereof. So when it comes to child and spousal support, the court will decide that. But sa spousal support, automatically, yung sinuport ng other spouse will be deducted doon sa share niya kapag liquidated na yung separation of properties nila. So, when we say pendente lite, this is the waiting for litigation. So, litigation is the process of taking legal action. So, while it is still in the process, the court will decide kung sino ba yung magbibigay ng support doon sa child, depende nga doon sa financial capacity no spouse. Next, we have the property regime of unions without marriage. So when a man and woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salaries shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. When we say co-ownership, this is the exercising same ownership rights as someone as a property. It has its own legal and financial process. So co-ownership, this is also called joint ownership. Since they are not married, there are no papers to support the regime of properties. So the legal support there is the co-ownership, wherein the mga properties or money or na-acquire nila anything na paghahatian nilang dalawa or own nilang dalawa as while they are living together. This applies for for those live-in partners. So in the cases of cohabitations not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. So yun nga, in the cohabitation agreement, it is the legally binding of contracts provided that they are drafted and executed properly and are signed as deed. So, signed nilang dalawa yun as that properties is owned nilang dalawa or the properties na paghahatian nilang dalawa when it comes to separation of properties. In the absence of proof of the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply in joint deposits of money and evidences of credit. So yun nga, equal yung mga properties na paghahatian nila. Ang nakaiba lang dito sa property regime of unions without marriage sa marriage couple talaga is that sa kapag dumating yung separation of properties, yung owned ng dalawang couples, may mga legal basis na paghahatian nila yun. And when it comes sa mga donations, pwedeng makadecide dun kung kanino yun mapupunta. Wherein dito sa without marriage, hati talaga siya. Unless hindi listed yung properties na yun doon sa co-honored nila na mga properties. Rights of legitimate children. So who are the legitimate children? Children born after 180 days following the celebration of the marriage and before the 300 days following its dissolution or the separation of the spouses shall be presumed to be legitimate. So children conceived or born during the marriage of the parents are legitimate. So children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor are likewise legitimate children of the husband and his wife, provided that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. So when it comes to insemination naman, if it is a donored sperm cells, dadaan siya sa mga legal authorization as long as may authorized papers na nagpapatunay na legitimate children nila yon, and it was signed by both the spouse na legitimate children nga nila yon or legitimate child nga nila yon. The instrument shall be recorded in the civil registry together with the birth certificate of the child. So, when it comes to legitimate children have also the right. So, they have the right to bear the surnames of the father and the mother. They have the right to receive support from the parents, their descendants, and in the ascendants, and in proper cases, their brothers and sisters. This pertains when kapag separated yung parents nila. So, they have the legitimate children have the right to receive support from their parents, both of their parents, to be entitled to the legitimate and other successional rights granted to them. So, it is few of the rights of the legitimate children kapag magsaseparate yung parents, or even parents will be still intact. Lastly, we have the equal rights between men and women. So, the husband and wife are obliged to live together, observe mutual love, respect, and fidelity, and render mutual help and support. So, since they are married, they have the obligations to love, respect, and render mutual help and support towards each other. So, the husband and wife shall fix the family domicile. In case of disagreement, the court shall decide. So when it comes to family domicile, the court shall exempt one spouse from living with the other if the latter should live abroad or should work from a distant place. The spouse are jointly responsible for the support of the family. So they have, when it comes to expenses and support, the conjugal obligation shall be paid from the community property, since they have the conjugal properties listed in the community property. Expenses shall be less in that community property. The management of the household shall be right and the duty of both spouses. When one of the spouses neglects his or her duties to the conjugal union or commits acts which tend to bring danger, dishonor, injury to the other or to the family, the aggrieved party may apply to the court for relief. So, the factors of this is that those negligence of obligations, and another one is having an affair. So, the aggrieved party can apply to the court for relief. Either spouse may exercise any legitimate profession, occupation, business, or activity without the consent of the other. The latter may object only on valid, serious, and moral grounds. So, each spouse has the right to exercise legitimate profession without the consent of the other, as long as it doesn't bring dishonor or it will not separate the marriage of the spouse. And if the other spouse cannot agree with that exercise of profession, it shall be validated in the court for valid and serious moral grounds. So the court will decide on that matter. So that could be all our report. Thank you so much for listening, and God bless everyone.